Have you found yourself in a situation where you've rendered services, where you've done work, where you've delivered perhaps materials to someone, but you were not paid merely because there was no contract in place? Is that fair? In today's video, we're going to look at what you can actually do if you found yourself in such a circumstance. Hi, my name is Councillor Singre Joan, and welcome back to Law Joan. The first thing that we consider in such a particular circumstance is we look at whether there was an offer in place, whether this offer was accepted, and whether upon accepting this offer, services were delivered. And upon the services being delivered, were they accepted by the person who made the offer? Did they benefit the person? And if they benefited the person who made the offer, yes, would it be fair for that person not to make payment? In this particular case, the principle that is employed is the quantum meruit principle. What is the quantum meruit principle? The quantum meruit principle is a Latin phrase that merely means that a reasonable sum of money is supposed to be paid for services offered and for work done where an amount of money is not stipulated in a legally enforceable contract. In such situation where we're employing the quantum meruit principle, we are looking at the end of the day to bring justice and equity to the person who has not been paid. Quantum meruit is an equitable remedy that targets against unjust enrichment. What is an equitable remedy? Some of you may be wondering. An equitable remedy is a contract remedy, yes, that looks at compensating the person to a position they have been previously in case the breach did not occur. What do I mean by this? This is a remedy that actually puts the person back to the place where they were before the harm was all caused. Let's take an example of implied contracts. Implied contracts are contracts whereby they're implied by conduct. In simple terms, these are contracts where two parties come together. In their mind, to them, they are entering into a contract. But, however, the actions they take show that they're actually entering into a contract where one is providing services and one is paying for these particular services. Let's take an example of the case of Firemasters versus Batu Limited. It's a 2019 case. In this case, what actually happened is the police procured for services where there was a fire in this particular place. And in cases of emergencies, honestly, no one has the time to go through formalities of our contract. So Firemasters provided services which took about 48 hours. These services were procured and accepted, and police greatly benefited from these services. We would say in such a particular case, if the person who provided the services is not fairly compensated for their services, this would be unjust and this would be unfair. Therefore, that's why we employ the equitable remedy and the quantum meruit principle in this particular case to bring redress to the person procuring the services to be paid. The most important key takeaways in such circumstances is that the main important thing is to gather evidence to show there was actually a contract. And there being a contract, there was an offer and this offer was accepted. When this offer was accepted, services were procured and Upon services being procured, they were accepted and greatly appreciated by the person who procured the services. When we look at the recent court decision that was passed on 29th January 2024, in the case of Dr. Mugarura Rodney versus Paramount Hospital Limited and Dr. Begumisa Simon. In this particular case, you could see that Dr. Rodney procured evidence. Which evidence did he procure? WhatsApp messages. Yes? WhatsApp messages. Dr. Begumisa Simon reached out to Dr. Rodney through a WhatsApp message, asking him if he could provide services as a surgeon at his hospital. Dr. Rodney went ahead and accepted the offer and went ahead and performed surgery on a couple of patients. And upon performing surgery on a couple of patients, Dr. Rodney went ahead through a WhatsApp message and sent to Dr. Begumisa Simon saying that these are the particular surgical implants that I've used. I've used 8 screws, I've used 6 screws, and he went ahead to write an invoice of how much the professional fees that were supposed to be paid to him for his services. So, what do we get from these facts? We get that, yes, there was an offer, there was acceptance, there was provision of services. These services were greatly benefited from by the person who procured those services. In this particular case, looking at the fact that there was evidence and there was overwhelming evidence of services being procured. And when you look at the quantum meruit principle, it mainly looks at the crucial element of, yes, were the services delivered? Yes. Did the person who procured them benefit from them? Yes. Basically, where an amount of money that is supposed to be paid for services or work done or materials delivered is not put in an enforceable contract. The principle is of the view, or it encourages that one is supposed to be paid a reasonable amount of money where there is no formal contract in place and these services have been provided and they have been benefiting from. It would be really unfair for the person not to be compensated, because at the end of the day this would amount to unjust enrichment. So the key takeaways from this is, please, if you find yourself in a circumstance where there is no formal contract in place, the most important thing to do is to gather evidence for future, security. How do you gather evidence? In the recent case that we referred to of Dr. Mugarura Rodney versus Paramount Hospital Limited, a voice note that is recorded and can be subsequently referred to can amount to evidence. Section 14 of the Electronic Transactions Act says that by the mere fact that a contract was in form of a data message, it does not take away its legal effect. Meaning, at the end of the day, if you have a contract through phone, please record that conversation. If you have a contract via WhatsApp messages or text messages, please record that. Evidence can be gathered in various forms. You could take a picture, take an example of where you're constructing a building. You can take pictures of the before and after. You can gather evidence through receipts. Yes, as long as you have evidence that there was a contract in place, and you also have evidence for work done, then you can go ahead and seek remedy. And if you feel like this kind of content can actually benefit someone, please kindly share to that person. Please kindly leave any questions that you have in the comment section. I'll be happy to reply to them. This is Law with Joan, and I'm Joan, and until next time, bye.